All rise. For the District State Court is in session. Now, Richard B. Orkin, Chief Judge, presiding. All presenting business for this court, draw near your attention, you shall be heard. The gospel of the United States of America, Florida, and this honorable.
Good morning and welcome to the 5th District Court of Appeal. We're here this morning for oral arguments, and on the panel this morning, joining me is to my right, Judge Vincent Torpy, and to my left, Judge Alan Lawson. We have several criminal cases as well as several civil cases. We'll take them in the order that they are listed. If you have a cell phone, we'd appreciate it if you would silence it so that the parties don't get interrupted during their discussions. And we'll go ahead and call the first case, Santiago versus State. Give me just 1 minute to get to my notes, please. Would you like to reserve some time?
Please reserve 5 minutes of my time for rebuttal.
Okay. Whenever you're ready, sir.
May it please the Court, my name is William Pinnell and I represent Francisco Santiago, the appellant in this case. Mr. Santiago's conviction should be reversed in this case for 3 separate reasons. The first reason is that the trial court abused its discretion in permitting the state to present several witnesses who provided hearsay testimony about statements the alleged victim made to them outside the court. The state was permitted to present hearsay testimony from 5 separate witnesses, and there was a total of 7 witnesses the state presented at trial. So 5 of the 7 witnesses were permitted to present hearsay testimony regarding the alleged victim's report of the allegation she made against Mr. Santiago. You had Janet Martinez, the alleged victim's mother, Tanya Liriano, the child protection team interviewer, Detective Torres, the investigating detective, Stacy Burdett, the principal of the elementary school, and the alleged victim herself, who all provided testimony about statements she made out of court about this allegation. It's our contention, and we rely primarily on the Pardo decision from the Florida Supreme Court, where the court acknowledged that child hearsay is admissible pursuant to 9803 subsection 23, even where the child testifies at trial, but the court held that the trial court still must perform the balancing test under 98.403 and ensure that the probative value of this hearsay testimony is not outweighed by the danger of unfair prejudice. And the court went on to say that there's a real danger of unfair prejudice where the child victim's allegations are repeated over and over again by respected adult witnesses. The court said that this danger would seem to us to be especially acute in criminal cases like the present, where the prosecutrix is a minor whose previous out-of-court statements are repeated before the jury by adult law enforcement officers. The court continued and said, by having the child testify and then by routing the child's words to respected adult witnesses, such as doctors, psychologists, child protection team specialists, police, and the like, with the attendant sophistication of vocabulary and description, there would seem to be a real risk that the testimony will take on an importance or appear to have an imprimatur of truth far beyond the content of the testimony. It's our contention, and I believe the record bears out, that the situation described by the Supreme Court in Pardo was the exact situation that existed in this case, in which the trial court allowed to exist in Mr. Santiago's case. The alleged victim's accusation against Mr. Santiago in this case was routed through various respected adult witnesses. You had the alleged victim's mom, an elementary school principal, a child protection team interviewer, and a police detective. So you have 4 respected members of the community: a mother, a principal, an interviewer, and a detective.
What statements of the child did the interviewer testify to? What out-of-court statements?
The interviewer actually didn't testify. She gave the predicate for the introduction of the taped interview she did of the child. So, Your Honor, you're correct that the interviewer actually didn't relay any statements, but she was the conduit for the state to introduce the out-of-court interview she did of the child. So that was a separate instance when these out-of-court statements were introduced for the jury to hear once again.
And what about the mother? My understanding of what the mother testified to was not what the child said to the principal, but that she observed the child speaking with the principal.
The mother, I believe, Your Honor, testified to two things, that the child came home and testified and told her that Mr. Santiago placed his tongue in her mouth, and secondly, that she observed the alleged victim talk to the principal. So there was two out-of-court hearsay statements from the mother. So, again, we have four well-respected members of the community and the alleged victim providing testimony about her out-of-court statements. She testified herself that she told her two friends at school, she told her, and that she told her mom. So we have, again, 5 separate witnesses testifying about statements that were made out of court that were hearsay. And this testimony, again, 5 out of the 7 state witnesses. And this testimony was addressed extensively by the prosecutor in both opening statement and closing argument.
Let me ask you this. In Pardo, the Supreme Court talked about the danger of doctors, psychologists, police officers, and other adults who are highly respected recounting the allegations in sophisticated language and that kind of thing. That sophisticated language part, the retelling, I don't see that in this case. I mean, like with the police officer, he may have one time mentioned tongue and mouth, but the rest of the time his statements were just, okay, she made an allegation, and what's your response? I mean, he was trying to elicit a response, but I don't recall in reading that any instance in which he, in any kind of sophisticated language, relayed any of her statements. Would you address how that point? Because it seems like Pardo in that respect could be distinguishable.
Your Honor, I guess I would disagree. I think the language used to describe the allegations by these witnesses weren't sophisticated, but the appearance these witnesses made on the stand was far more sophisticated than the child victim. The child victim's testimony was not a clear narrative. She seemed confused by the surrounding circumstances. These other witnesses, due to their age and because of their positions and because they are more sophisticated, gave a much more sophisticated appearance and, by definition, actually, bolstered her credibility just by the fact that they were able to give more sophisticated answers to all the questions they were asked. I would agree with the court that the description of the allegation by the hearsay witnesses was the same, wasn't particularly sophisticated, but their appearance was sophisticated and their answers to all the questions they were providing.
That's not a reason to disallow a witness. I mean, you don't disallow a CPI interviewer to testify because in laying the predicate for admission of the tape, she might be more sophisticated than a child. I mean, I
guess I would disagree with the court. I think that the meaning of Pardo is that by allowing sophisticated witnesses to repeat this allegation over and over again.
I just don't see the allegation repeated over and over again, certainly not in a sophisticated way, but the CPI investigator didn't repeat the allegation. The police officer maybe did one time, but that's certainly not the bulk of his testimony. I don't recall the mother doing it. I just recall her saying that this is what I saw her. Maybe you could give us the site to where the mother repeated it, but I just don't see that the hearsay statement was repeated, certainly not in a sophisticated fashion, but not even that much by the witnesses you're talking about.
Well, I guess, Your Honor, again, I disagree with the court. I think that the detective, although only specifically said the actual allegation about the tongue in the mouth one time during his interrogation of Mr. Santiago, over and over again he said the alleged victim told us something else happened there. So the jury clearly got the implication that this detective had talked to the child and that she had made an allegation against Mr. Santiago, and he stated that over and over again during that interview. The specifics of the allegation, you're right, were only said once, but it was repeated over and over again that there was something else that occurred, and the jury clearly got the idea that an allegation was made by the victim to the detective, and it's our contention that by repeating it through these various witnesses who are sophisticated, and what the Supreme Court is talking about is you can't allow multiple witnesses who are in respected positions in the community, who talk more sophisticated than the child, to bolster the credibility of the alleged victim by testifying in this manner. It may have been different if the court solely allowed the mom to testify, but you had 5 out of the 7 witnesses permitted to testify So it's our contention that under these circumstances, with the number of witnesses, 5 out of the 7 state witnesses, with the opening and the closing, that it was an abuse of discretion under these circumstances, and that the sophisticated part doesn't have to be the language used to describe the allegation, but the fact that they hold sophisticated and respected positions in the community. So we believe that that's what the Pardo decision stands for, and that's a situation we have in this case. Multiple respected members of the community repeating the allegation over and over again, and these hearsay statements pervaded the entire trial, both through the testimony, in opening, and in closing, and during the 2 recordings that were played for the jury, the CPT interview and the interrogation of Mr. Santiago by Detective Torres. So we believe that the introduction of those numerous hearsay statements requires this court to find that there's an abuse of discretion and to reverse Mr. Santiago's conviction. And I'll reserve the rest of my time for rebuttal.
Thank you, sir.
May it please the Court, good morning. My name is Kelly Neal, and I'm here on behalf of the state of Florida. It's our position that this argument, to the extent that it's made on appeal, was never presented to the trial court. In trial, they had the hearing on the admission of child hearsay under the child hearsay exception. At the conclusion of that, there were 3 witnesses: the mother, the principal, and the CPT investigator. The state withdrew its proposal to put in the statements that were made to the investigating Detective Torres. The defense objected that it's cumulative, more prejudicial than probative. The trial court then went through all the child hearsay findings and said it would be admissible, and the defense never obtained any ruling whatsoever on their relevance objection. So it's our position that this issue isn't even preserved for appellate review. Again, it only went to 3 of the witnesses. Counsel keeps talking about these 5 witnesses.
If they object at the hearing on that basis and the trial court allows the testimony, I'm having a hard time understanding why that's not a ruling.
Because the trial court just ruled on the child hearsay factors of it. The trial court was never asked to do a weighing. Your Honor, could you exclude the testimony of this witness? You know, we already have the CPT, we have the mother, we have the victim. There was no parsing out of an objection. It was just kind of a bald assertion covering everything. And like I said, the trial court was never asked to weigh the probative value against the prejudice that could have come from this. And there were only 3 of these.
The defense counsel said allowing all these people to come in and testify is really an attempt, in my opinion, to bolster the credibility. And it goes, I mean, some of the same arguments were made in front of the trial court that are being made here. I don't know why that's
true. They never got a ruling on that, though. And again, there were only 3 of the witnesses that testified at the child hearsay. So now he's claiming 5 witnesses who had high standing in the community. First, I'd like to point out one of those was the victim. There were only 4 additional witnesses. And only 3 of the witnesses testified at the hearing where the objection was made. So I think this is just, it's a much more extensive argument that was ever presented to the trial court. And the trial court really didn't have an opportunity to rule on this. And maybe say, well, you're right, maybe we shouldn't let the mother testify. We do have the CPT investigator. So that's why I think it's really not preserved to the extent that it's presented on appeal.
Okay.
As far as the principal's testimony, the principal testified she didn't even believe the child. So, and the detective testified that the principal told him that too. So certainly her testimony couldn't have been prejudicial. So really all we have then is the mother saying the child came home and told me, and then we went to the school and she told the principal. And the CPT investigator. And I mean, this is pretty standard in all trials. It certainly doesn't, and that's one of the reasons that child hearsay comes in, is to corroborate the victim's testimony. So even if this claim was preserved, it's our position that the trial court did not abuse its discretion in letting in this testimony. And again, even if it was, it had to be harmless. We had his statement saying that whatever she said I did, I'll admit to. I just want this over with. And in light of the other testimony, the victim's testimony, the jury had a chance to observe all these witnesses. So if there's no further questions, I'd ask this court to affirm. Thank you.
Thank you.
Please, the court. First, at volume 5 of the record at page 184, the mom did testify specifically that the the alleged victim came home and told her that Mr. Santiago placed his tongue into her mouth. So the mom testified to that, and additionally testified that she observed the alleged victim relay the allegation to the principal. As to whether the issue was properly preserved, the court properly indicates that there was a bolstering objection, and then the defense attorney also indicated that the testimony would be cumulative in nature and therefore more prejudicial and probative, and it's bolstering a witness. So the objection was made repeatedly. It tracks the language of 90.403.
Your brief makes the point that that there was testimony elicited at trial without objection that was not covered in the hearing, and you said that that's problematic. You I guess acknowledge that with respect to that testimony, that's got to be a fundamental error analysis. There was no objection at trial, correct?
Correct. That would be correct. I guess there's two issues with that. It wasn't, the state didn't give notice to Mr. Santiago and his defense attorney, so certainly it wasn't part of the hearing because there was no notice. Then the state sought to introduce that testimony without providing notice.
And there was no objection?
Correct. There was no objection. So we would argue, one, it's fundamental error because this hearsay pervaded the entire trial, and secondly, that it was ineffective assistance of trial counsel to not object to that testimony because there was no reasonable strategic reason not to do so. It wasn't noticed. The case law is clear that you have to notice it. The statute's clear that you have to notice it, and it's our contention.
Do you see any difference in our review of those two issues? In other words, if there's not fundamental error, aren't there Supreme Court cases suggesting that we couldn't find prejudice for Strickland analysis on this record, considering any potential ineffective assistance of counsel claim?
Could you repeat the question?
Okay. As I look at some of the Supreme Court cases on this issue, they have an analysis there. There's no fundamental error, and then they get to a claim like you're making that there's ineffective assistance of counsel on the face of the record, and they say since there's no fundamental error, then there's no prejudice. So really, they sort of meld those two analyses together.
Your Honor, I would respectfully disagree. I think the fundamental error standard is a much higher standard than the prejudice prong of the Strickland standard. I think fundamental error, they say, has to go to the heart of the trial. The prejudice standard under Strickland and all its progeny is a reasonable probability that the outcome of the trial would have been different. So I think that trial counsel was deficient by failing to object, and that there is a reasonable probability that had this testimony been properly precluded because it wasn't noticed, wasn't part of the hearing under 90.80323, there is a reasonable probability that we have a different outcome. And the state wants to tell the court that there's a confession here and it's harmless error and there is no prejudice. I don't think it's a proper characterization of Mr. Santiago's statements during the interrogation to call it a confession. We have him repeatedly denying the accusation. And then the detective tells him, well, maybe if you just tell me it was a lapse of judgment, maybe the mom won't want to prosecute, maybe it'll all go away. And then Mr. Santiago says to the detective, if this will make this go away, I'll tell you I did it. It's clear, it's not a regular confession. One reasonable way to look at this.
This will be my last question. I know you're almost out of time, but because of that, I really didn't get your latter argument that the trial judge should not have allowed the tape to be played because the officer statements in it, were too prejudicial. Because to me, I mean, if you didn't have the tape played, what you'd be left with is the officer testifying that he confessed. But by allowing the jury to see the whole tape, you see the context, the pressures that the officer put on the defendant, his responses, and you see exactly what you're saying, that there was, it's what that confession means, I think, is a question of fact that could be argued.
Sure, I understand that. I
don't know how you get that unless you play the whole tape.
Sure, I think that's a good point the court makes, but I think that the tape and the detective statements go a little too far, and portions of that could have been redacted appropriately and still the jury would have still been able to see that Mr. Santiago didn't change his story until he was offered this carrot. I think that the detective made statements that that the alleged victim's testimony was credible, was consistent, even under questioning by, quote, professional interviewers. I think that type of information, which improperly
The defense lawyer never asked to have it redacted, right?
Correct. You're entirely correct about that, and that's why it's a fundamental error analysis or
So the
ineffective
trial
system.
judge has got to do the redacting on his own, I guess.
I think at some point, Your Honor, when it gets to a certain level, the trial judge does have some duty to intervene, and I think that level was met in this case.
Thank you, sir. You've exhausted your
Thank you,
time.
sir.
Thank you, Your Honors.
All right,